Good afternoon, everyone. Hopefully you can all hear me okay. For those of you who don't know me, I'm Gillian Hartness and I'm a director in the third sector team at Burness Paul. I'd love to say that I'm really delighted that so many of you are joining us, but that's not technically speaking true. Please don't be offended by that, but I'd rather you were off doing the core of what you do, working with your beneficiaries, rather than having to hunker down and weather the storm. I'm reading the Harry Potter books to my 6-year-old son at the moment. And for Harry Potter fans out there, we're on the 5th one at the moment, which is the one that gets quite dark and almost relentlessly miserable, I would say. And one of the characters in the chapter we read last night was saying she wished she could close her eyes, go to sleep, and then when she wakes, discover this had all been a bad dream. And I think a lot of us could probably empathize with that feeling right now in terms of the pandemic and our thoughts. But this too will pass, and there are always reasons to be hopeful, whether it's the 560,000 plus individuals who've signed up to volunteer for the NHS, whether it's acts of community kindness, and again, a lot of charities are the ones who are orchestrating that. In the meantime, what Morag and I are hoping to do is to equip you, help to guide you through these difficult times so that we can weather the storm together. The focus of today's session is going to be on employment. I will pick up a little bit of governance at the end, just on some queries that we are being asked by a number of charity clients. So I'm seeing people are saying they can't hear, but some people are saying they can hear. Is that okay? Can most people hear? Can anyone give me a thumbs up? I'm getting a thumbs up from a nice man down there. Thank you. So the focus today is on employment, but I will be picking up a bit of governance at the end. But actually, I'm going to do a session next week on a number of issues relating to charities because I'm getting more of a sense from clients of ours as to some of the big issues that are coming in. I have to do a few housekeeping matters first of all, so nothing to do with fire alarms or directions to the toilet as I normally have to do. The first thing to say is that we have unceremoniously stuck everyone on mute, and we would ask that you keep yourselves on mute so we don't hear washing machines or dogs yapping. There are so many of us on here. But obviously, please do use the chat facility, and I will be monitoring that when my colleague is speaking and taking a note of things, and then I will interrupt her at an appropriate point and put some of those questions to her in an anonymised way. The second thing to say is that we are recording this today to make it available to people who cannot join, and in a legal way, I would refer you to the privacy notice on our website. Please also have a look at the Burness Paul website for the coronavirus hub section. There's loads and loads of useful information there. And the third thing to mention is that WebEx have said there may be some capacity issues just because of the numbers of us joining. So if it all goes horribly wrong, we will reconvene and we'll be in touch with you on that. I'm joined today by Morag Hutchison, who is a partner in our employment team, and Morag has massive experience in advising third sector organisations on employment matters. I would also say that a more human and reassuring presence you couldn't really hope to find than Morag at the moment. So over to you, Morag.
Thanks, Gillian. Welcome, everybody. As Gillian says, we're delighted to have you join us, but I appreciate this is it's tough times and tough topics that we're going to be talking about today. What I'm keen to cover, I think the kind of key topic on many people's lists is this whole issue of furlough, and we'll come to look at that and talk about that. I thought probably, in my mind, I've kind of split things up into two phases almost. Phase one for me is round about what payments should be paid to staff who are self-isolating, or staff that are unwell, or staff that can't come into work, because I imagine that's one question that a lot of you will have. Many of you may have already dealt with that almost kind of in the immediate response to COVID-19, and you'll have that set up. Others might still have some questions on that. So spend a little bit of time looking at that. I'm then going to spend probably the majority of the time looking at furlough. So how that's going to operate in practice, and also dealing with some of the questions that many of you have sent in already, and just sharing with you some of the questions that we've had from clients as we've been working our way through furlough over the last week or so. I thought it might be helpful then just to touch a little bit on other options. So if you're not looking at furlough and you're looking at the sustainability of your charity, what other options might be available to you? Again, a little bit of time just looking at critical workers. Many of you, I know myself, I'm a trustee of a charity where you're providing critical services to people in need at any time, and that is a service that many of those individuals will need even more so now. So many of you will not be in the position where you can simply send all of your staff home and ask them to work from home. You'll have people that are on the front line, and there's obviously issues to be looking at there. And then finally, just some other bits and pieces that I thought it might be helpful to cover. So I hope that sounds like it will be useful for you. If we start first then on the payments, if we kind of split your staff into different categories, if you like, the kind of key ones that I would suggest are there. Firstly, those individuals who are self-isolating as per government guidelines. I think it's fairly clear now that the position there is that they should be getting paid sick pay. You'll know obviously that statutory sick pay now kicks in from day one of that absence, rather than the delay that was in place previously. Many of you will be charities with under 250 staff, so you may be aware that the government have confirmed that they will reimburse employers with 250 staff or less for the first 14 days of statutory sick pay, which is obviously of some assistance. So that's your individuals who are self-isolating under government guidelines. And that'll include people who are self-isolating because they may have been exposed to COVID-19. It'll also include those who are self-isolating because a member of their family may have been exposed to COVID-19 or is showing symptoms. So you'll be aware that there's an obligation now on households to self-isolate for a period of 14 days if anyone within their household is demonstrating signs of COVID-19. What about individuals who are self-isolating through choice? So these are people who don't necessarily fall into the vulnerable category, and it may be that they, you still need them to come into work, so they're viewed as critical workers. They're not banned from work travel, but they've said to you that they want to self-isolate for their own reasons. Strictly speaking, they're not absent through sickness, so they're not entitled to sick pay. What I would say to you, though, of course, is just be aware that there may be a good sound reason why they are self-isolating. If that's any sort of medical capacity issue that could be a disability, then potentially there's obligations on you there to make reasonable adjustments. And I guess the other thing I would say to you, is at a time like this, if you do have individuals who are saying to you that they want to self-isolate, but they don't fall under any of the government categories, obviously I'd say look at that on a case-by-case basis and use your discretion where appropriate. The third category I've got are your individuals who are working from home. For those of you that are in a position to send staff home and have them work from home, obviously if they are working as normal, then they're entitled to be paid as normal. I'll kind of come on when we look at the different options in terms of sustainability later on in the session to look at, well, what if you've got individuals who are working from home and either are not able to do a normal day because they have childcare responsibilities. I don't know if many of you are in the same situation as me at the moment, where we have two small children at home, and I have a newfound respect for school teachers, I have to say. I think we've had about 7 tantrums this morning already. So what about those individuals who have children at home now and are not able to work their normal hours? What are the options there? And then you'll also have individuals who are, you wouldn't necessarily view as critical workers, so they're no longer travelling into work, but they also are not able to work from home because of the nature of their job. What payments are you due to those individuals? Well, for those individuals, because they're not off sick, unless your business has closed down and sent them home, then arguably they're not entitled to any payment if they're just not able to work from home. And as I say, we'll come to look at the various options like unpaid time off, taking holidays, reduced hours, etc. When we come to look at the kind of phase 2 issues round about sustainability of your charity and how you look at saving costs in order to continue both during this period of COVID-19, but also in the longer term when you come out of the back of that also. Just looking at the question there, so what if someone has been advised to self-isolate because of underlying health conditions, but they're in fact okay to work from home? Should we be advising them not to be working? Been asked this quite a few times. I would have a conversation with them. If they feel well enough to work from home and they would rather do that because they would rather receive their pay, then I would allow them to work from home. If you feel that they are not well enough to work from home and they're not able to do their job, then I would be having a conversation with them about that separately. But you will have a number of people, for example, who are self-isolating, perhaps because a member of their family is displaying symptoms of COVID-19, and strictly speaking, they're then sickness absence also are entitled to SSP. But if they're well enough to work from home and are continuing to work from home, then I'd be paying them their full pay during that period. So that takes us on to sort of phase two, if you like, sustainability, and how you deal with this ongoing issue of not being able to provide your services but having to continue to pay staff. And the key topic of furlough, which I know everybody is super keen to talk about. My word, until this time last week, I don't think many of us would be speaking about furlough or social distancing, all these new terms that are now coming into our vocabulary. Furlough is effectively a fancy word that you would use for effectively laying staff off. It's not a UK employment law concept at all, but it is something that's been used in the US for a while. But if you think of it as a new way of asking staff to stay at home and not come into work, you're effectively laying them off for a period of time. It is, however, and this is quite important, it's different to the existing legal right to lay staff off. Some of you may, in your contracts of employment, have a clause that allows you to lay staff off whilst there is a downturn or whilst you don't need them to come in and provide their services. It's gosh, it's interesting. It shows how employment law, how things change. Those clauses tend to have been, they're kind of viewed as sort of 1970s, 1980s clauses that you would tend to see in manufacturing contracts. And so it's quite rare to see them in more modern contracts of employment. If you have a layoff clause in your contract of employment that allows you to lay your staff off under the statutory scheme, you can use it, but the only warning I would give to you on that is if you're using the statutory right to lay off under your contract of employment, once you've laid staff off for a period of 4 weeks or 4 continuous weeks or 6 weeks within any 13-week period, they are then entitled to be made redundant. And I flag that for any of you who have final salary pension schemes, that is potentially a big issue, because if you lay people off and they are then entitled to ask to be made redundant, they may have very enhanced benefits under their pension scheme in that situation. So it could be quite a significant cost for you. So I'm talking to, there's maybe none of you or only a few of you on the call who have layoff clauses in your contract of employment and you're considering using them. Rather than using them, you might want to use the furlough scheme instead. For those of you that don't have those clauses in your contract of employment, forget everything I've said in the last 5 minutes and we'll focus on furlough instead. But the key difference between furlough and layoff, the statutory layoff scheme that's already in place, is if you place staff on furlough, they don't have the same entitlement to then come to you and say, I now want to be made redundant. So it gives you more flexibility as an employer, and that's one of the key benefits of the furlough system. All right.
Sorry, could I just interrupt
Of
you for
course,
2 seconds?
yeah.
I don't know if this is the best time for this question, but we have been asked about someone who has funding in place, which is very common in the third sector, funding to cover a particular post, and that is up at the 30th of June, and the staff member, that would then be their contract ending, as it were. They wouldn't be able to look for another job as no one is recruiting at the moment. Is there any provision covering this that you're aware of?
No, there isn't. So in normal circumstances, I imagine you would either renew the funding and continue with the role, or if there's no renewed funding, you would be looking at a redundancy effectively. And if that employee had less than 2 years service, it would be fairly straightforward. You would simply bring their contract to an end and pay them their notice money. In this new world where we have the ability to furlough, the purpose of furlough is, or what the government have indicated is, you should be using furlough where you've got an individual who otherwise would be getting made redundant. So if you've got someone who is on set funding for a particular job, if you can continue them in that job because you've got the funding for it and they can continue to perform the role, then you strictly speaking, you shouldn't be furloughing them. What you should be doing is continuing to pay them under the funding that you've got and then bringing the employment relationship to an end in the way that you normally would in the normal course of business once that funding runs out. If, however, that person is performing a role and you've got the funding for it, but they're not able to perform the role for whatever reason now, perhaps because of the effective lockdown that we're under, then they could possibly be put under furlough in that situation. So I hope that helps answer that question. Let's talk about furlough itself then first. Let's talk about how it's actually going to operate in practice. A big kind of a caveat that I need to give to you is the guidelines on furlough have not yet been issued by the government. So there's a lot of speculation out there about how furlough is actually going to work and the details of furlough. We're anticipating the guidelines will come out either tomorrow. I don't expect it's going to be today because today we're expecting the announcement on self-employed and what the government are going to put in place for self-employed individuals. So we're anticipating the guidelines on furlough are going to come out tomorrow or the beginning of next week. What that means is a lot of what I'm going to say to you is this is what we think, but it will depend on the detail of the guidelines. Okay, so I'm going to try and give you as clear answers as I can. So there is some stuff that we do know and I can tell you what that is. And on the stuff that we don't know yet, I'll explain to you what we think is going to happen. And obviously what we will do as soon as the guidelines come through, I expect we may organise another WebEx next week, but we're also likely to do a document that sets out the information and the guidelines so we can make sure we can share that with as many of you as we can. So how does it operate in practice? Okay, the way it's going to work is employers are going to have to contact HMRC and ask HMRC for a grant. That is going to be done through an online portal, which is in the process of being set up at the moment. And as you'll have heard the Chancellor announce next week, what they're hoping to do is be in a position to start making the first payments at the beginning of April. I think that's quite optimistic. It's probably more likely to be the end of April, and I expect the system will be quite overwhelmed. That is very relevant for each of your organisations because what you have to give some thought to is if you're going to put staff on furlough, when are you going to do it? And are you going to put them on furlough and say to them, we will continue to pay the 80% to you now, and then when we get the grant in from HMRC, we'll keep that effectively. So we're paying it to you and then we're then recovering it from the government. Or are you going to say to your staff, we're going to have to put you on a period of unpaid leave and we're going to apply for the grant. And if we get the grant and as soon as the money comes through, we will pay it to you. Now that will very much depend on your own individual cash flow situation and any wording around contractual documentation that you enter into with staff that you put on furlough is going to have to be very carefully drafted because what you don't want to get yourself in a position of is saying to your staff, we're going to put you on furlough, you'll get 80% of your salary, and then for whatever reason the grant doesn't come through to you or it's delayed for a prolonged period of time, or there's rules introduced through the guidelines that mean for some reason you don't qualify for furlough. You don't want to create a situation where you're given a commitment if you don't actually get the grant money through, if you're in a position where your funds are particularly perilous. So just a word of warning there. What is furlough going to do? Furlough is going to pay 80% of your employees or PAYE workers' costs up to 80% or £2,500. There's been a lot of discussion about, well, is that 80% net or gross? The point that, again, it'll depend on what the guidelines say, but the view that's kind of coming through from commentary is that 80% will be the total of the grant, and it'll include national insurance contributions and this is another question that a lot of people are asking, any benefits. So for example, pension costs, etc. as well. So what the individual gets in their hand is not necessarily going to be 80% of salary. It may be 80% of salary less national insurance contributions. It may be 80% of salary less pension contributions that are then paid separately into the pension scheme. Or so again, there's some confusion lack of clarity on what will actually be paid to the individuals. So again, be careful in relation to any commitments that you're making there. I'm just going to pick up on pension very briefly. I've said to you that there's discussion that 80% will include pension. There's also some conversations around about it not including pensions, and employers being given the opportunity to pause auto-enrolment. So there's been some discussion that the government may introduce legislation that allows you to pause your auto-enrolment obligations. That's just been discussed about the last couple of days. I've not seen anything formal come through on that, but just to put it on your radar. So that's your 80%. What else do we know? Well, we know that all workers who are paid through PAYE are entitled to benefit from this scheme. So it's not just employees. Those of you that have attended seminars that we've done before, you'll maybe heard me talking about, you've got 3 categories of staff. You've got self-employed individuals, you've got workers, and you've got employees. This scheme covers workers and employees. It doesn't cover self-employed individuals. You'll have seen all of the publicity about that in the news. And as I say, it looks like we're going to get a scheme through for self-employed individuals announced today, but it does cover workers and it does cover employees. The scheme is backdated to the 1st of March. So if you, again, it's not clear here if the intention is, if you've had to already lay staff off as a result of COVID-19, are you able to claim back to the 1st of March for those individuals? That would involve you reinstating those individuals effectively, and then claiming back to the 1st of March. I think that's the intention, but it's not entirely clear. There was also some discussion about, well, if it starts from the 1st of March, does it mean that people that have been in self-isolation and are on SSP since the 1st of March get to benefit from it from that date? The answer to that, I think, is going to be no. I think the answer is going to be you will only get your 80% under the scheme once you are officially placed on furlough. So if you have staff who are classed as sick because they're self-isolating currently, they are not entitled to furlough, because it's only those individuals who are working for you who are at risk of redundancy and are not currently self-isolated. Now, of course, you will have individuals who are currently self-isolating who will come off self-isolation and at that point are likely to become entitled to furlough. But you can't be on both status at once. You can't be sick and furlough. You're either sick or you're furlough. And similarly, and we'll come back to this later on, you cannot be on holiday and furlough. You're either furlough or you're on holiday. Okay, and we'll come back to that. I see your question about 0 hours contracts, so yes, I'll pick that up. That's one on my list. So backdated to the 1st of March. Yes, Gillian.
Morag,
No,
there
you
are
go.
also another kind of couple of questions about fixed term contracts, again, staff where a contract's been extended, where I think there was an expectation of funding continuing and then the funding's been pulled. Would encourage the person who's put that in maybe to drop us an email separately on the funding agreement and really just to first of all check the basis on which the funder has pulled the funding to see whether there is any recourse on that. But the question is being asked is whether those roles should now be made redundant because the funding has been pulled and the contracts of employment were extended prior to COVID really hitting these shores.
Yes, so this again I think is a really interesting point because what the job retention scheme and furlough is designed to deal with is individuals who otherwise would be made redundant as a result of COVID-19. So if you have staff whose employment you would be bringing to an end notwithstanding COVID-19 for some other reason, like individuals on fixed term contracts, then strictly speaking furlough doesn't apply to them because the reason their employment is coming to an end is not COVID-19, it's because their fixed term contracts come to an end. However, if you have lost funding because of COVID-19, and that then means that you're making those individuals, you're terminating their employment earlier than otherwise you would have done, I think you could apply for furlough in that situation, probably just up to the period at which the funding would have expired. I don't think you'd be able to claim it much beyond that. But what I'm going to say on that, and this is a kind of, I suppose, a theme throughout all of this furlough discussion, is I don't know how HMRC or the government are going to check up to ensure that those that have applied for furlough are entitled to furlough longer term. And it covers this sort of issue of, well, if you're keeping on a fixed term contract and paying furlough, can you show that the reason that you're, the only reason that they would have been dismissed otherwise was COVID-19? Who's going to check that? How are people going to check that? I'm not for 1 minute suggesting then that you abuse the scheme in any way, but that's the reality. It's similar to the question that we're being asked around, what if you put someone on furlough, are they allowed to go and then work for another employer and earn salary from another employer? My answer to that has been, well, again, go back to what is the purpose of the furlough scheme, is to protect the income of those individuals who otherwise would be getting made redundant. It feels to me like it goes against the purpose of the scheme for you to be able to take 80% from one employer and then go and work for someone else and get an income that way. However, again, how on earth is HMRC or the government going to track that? Now, it may be that at some point in the future, they check back over records to see who's had what income at what point. It may be that it's a condition of acceptance onto the scheme and getting a grant that employers or employees are asked to sign a declaration to say that whilst they're on furlough, they will not take up alternative employment. But these are the kind of issues that we just don't have guidance on yet, and may not get guidance on, because I think the other thing, obviously, we have to remember in all of this is a big, bold scheme in reaction to a massive issue. And actually, if it protects lots of people and does the right thing, we maybe just have to accept that other people might benefit from it in a way that wasn't first intended.
Well, I cast you on a roll with
Yes.
questions.
Yes.
Sorry.
No, not at all.
Is it prohibited for those in furlough to do even a small amount of work?
Well, you see, my answer to that is at the moment, we don't know. The kind of view is that yes, it will be, because of what I've just said about what the purpose of furlough is. But in reality, people may end up going on and taking on other roles and getting paid furlough and getting paid for the alternative role. What I would say is, I think if you are furloughed and you then go and do voluntary work, absolutely, I can't see there being any issue with that at all. But if you're furloughed and then you take on another paid job, unless of course you've already got 2 jobs, a lot of individuals will be working 2 jobs already. But I think if you're furloughed and then you go and take on another job, that might cause an issue in the future, but how is that going to be? How is that going to be monitored?
I'm going to ask you one more, and then probably the rest of them there are so many coming in that probably the rest of them, hopefully Emma, who is hosting this, can tell us whether we can collate these and come back separately on some of them. What if the employee is currently working their notice, having previously resigned or notified retirement? Can you move them to furlough during their notice period? That's my last one for now.
Yeah, no, listen, really good question. And what I will come on to do, it's brilliant that you're posting all the questions. I'll finish my chat on furlough. I've also then got a whole list of questions that we've been asked on furlough, so I'll go through them and I'll answer them, and hopefully they'll answer quite a few of the ones that you're posting. And then if there's any at the end that we haven't answered, we'll have a look through them and we'll try and come back to you on them. So if somebody has been given their notice or is handed in their notice and is due to leave on the grounds of retirement, or redundancy, or for whatever reason, furlough will not cover them in my view, because of course, if we think back, what is the purpose of furlough? It's to protect the salary of those individuals who otherwise would be made redundant. I don't think they are entitled to furlough. Where this has been coming up though is where you may have made an offer to an individual and they've accepted and they're about to join your organisation, but you would be either looking to withdraw their offer or immediately make them redundant. Are they entitled to furlough? Our initial view on that was, yes, we would think that they would be, because they've joined your organisation. The only reason that they're not working with you is because you don't have roles, and therefore it's a redundancy situation. However, what's starting to come out on the commentary and from HMRC is that the furlough payment will be based on your February salary. So if you've just taken someone on and they don't have a February salary with you, it may be that they're not entitled to furlough with you. And you might have seen, I think it was Martin, what's his name? The money saving expert.
Lewis.
Martin Lewis, yes. You may have seen some commentary from him where he is saying to individuals in that situation, what you ought to do is go back to your old employer that you do have a February payroll with, and you say to your old employer, can you take me back on, please, and then furlough me? That sounds all very well, but from an employment law perspective, that individual is no longer an employee of their previous organisation. So, for an employer to take them back on, they would have to do it in the way they would any employee who's left. You would have to start them up on a new contract and take them back on as an employee. And we have had a couple of clients who have had ex-employees who have unfortunately been caught really badly by the timing of this, and who've contacted them to say, I want you to take me back on and furlough me. But again, if you think about what's the reason for the scheme, the reason is to protect those individuals who otherwise you'd be making redundant. If you're the previous employer, you wouldn't have been making that individual redundant. They've left your organisation. So these are the sorts of issues that I hesitate to say to you, we can't give you clear answers on at the moment, but they are the questions that are being asked. So hopefully, even just for you to understand that they're the questions that are being asked and what our thoughts are, hopefully is of some assistance. Furlough, how long is it going to be played for? Well, Chancellor said at least 3 months, but he also said this is not capped. He also said it may be extended if necessary. I think obviously reflecting the situation that we find ourselves in. And we've also been told that they hope to make the first payments, as I say, beginning of April, middle of April. In reality, I expect you won't get payments through until the end of April. And we've got a number of clients. Different people on this call will fall into different categories. Some of you will be in dire financial straits and have to do something right now. Some of you will be somewhere in the middle where you're thinking we need to do something, but we can wait and see how things go. And some of you will be in the other category of, well, we're okay, we don't need to do anything at the moment. For those of you that are in kind of dire financial needs at the moment and you're thinking, well, how on earth can we wait until the end of April to get this grant payment through? I suppose what the government's saying to you on that is there's the emergency loan system that's available now as well. So do you look at applying for the emergency loan, trying to get that as quickly as possible, using that to pay your staff, and then when you get the furlough grant through, using that to effectively repay the loan. But remember what I said to you before about you need to think about, are you going to pay the 80% now in the hope that you get that back through the grant system? Or are you going to say to the individuals, we're going to put you on unpaid leave and as soon as we get the money, we'll pay it to you? And it will depend on your own financial positions.
There's also the Third Sector Resilience Fund, just to mention. I know that I think there are people from SCVO who are on here just now, and on LinkedIn and things like that, you'll see lots of information on that. Social Investment Scotland as well. I believe I've got a package of support, just to mention that. Thanks.
Yeah, and a good question that's come up there. What about your people that are on 0 hours contracts? How do you work out, can they furlough and what payments would be paid to them? Well, if they're on 0 hours contracts, there is a line of argument that says they're not entitled to furlough because it just means that you're not making them redundant, you're just not giving them any hours of pay. I think that's a harsh view. I think you can argue that, but for this situation, you wouldn't have been you would still be giving them hours of work. So I think they can go onto the furlough scheme, and I think that's a view that's been expressed by the Chancellor as well. But your second question then is, well, how do you calculate what their payment is for February if they've not had any income in February? What we've been saying to clients here is, I think you've kind of got two options. Well, one is you say, sorry, your income in February, you didn't get anything, so you're not entitled to anything, which again feels very harsh. The other option would be to look at their average income, perhaps over the past 12 weeks or perhaps over the past 12 months, and base the 80% on that. You might be taking a bit of a risk if you're paying the 80% and the government then, the guidelines do come out and say we're only paying 80% based on the February salary, but that's not, as I say, that's not something we've got clarity on at the moment, whether that is going to be how the way they operate it. So there's a number of options there. You either base it on February income. If there's no income on February, you say, sorry, there's nothing to be paid. Or, and again, it's perhaps for those of you that might have some more finance available to you, you could average out the hours that they've worked over the last 12-month period or 12-week period and base it on that. Who's not covered? As I said to you already, self-employed are not covered. Those that are self-isolating are not covered because they're treated as being sick and not furloughed. those that are working from home, if you're doing your job from home, you're not furloughed. So you're not entitled to payment under the scheme. So you may have staff where you think, oh, this would be really helpful because we could meet 80% of their salary costs up to the 2,500, but still get them to work. You can't. If they're still working, they're not furloughed, the scheme doesn't apply to them. Again, a bit of a sting in the tail. You might have agreed with some of your staff to reduce their hours but continue working. And you might think, well, that's great because we could top up their salary through the grant scheme. You can't, because they are not furloughed. If they're still working for you, albeit on reduced hours, they're not furloughed, and so the scheme doesn't apply to them. And actually what that does in practice then is perhaps encourages a lot of employers to say to staff, rather than us cut your hours and we're responsible for paying your salary, would actually be better to move you on to furlough and try and recover 80% of your salary through the grant scheme. Process. What's the process for putting people on furlough? Well, the government have been very clear that it's in accordance with normal employment law. So if you're placing employees on furlough, it's a change to their terms and conditions of employment. So you have the same obligations as you have whenever you're looking to make a change to terms and conditions of employment for staff. Strictly speaking, what you should be doing is agreeing the change with them. So your contract of employment is a bilateral contract. It's a contract between the employer and the employee. An employer cannot impose a change in that contract without getting the employee's consent, because both parties are party to the contract. So what you should be doing is getting the employee's consent to move them on to furlough. Now again, we've got different clients who are taking different approaches here. Some clients are saying to us, Morag, if we don't do this today, the business will fold. We don't have time to consult with our staff. We're going to impose furlough. And other businesses, other clients are saying, that's fine, we get it, we understand we have to go through a consultation process, we're going to do that. In reality, though, often the consultation will be, we need to change our terms and conditions here. If we don't, we're looking at a redundancy situation. So you need, again, to think about your own organisations. If you're looking to put people on furlough, where do you sit in that? What are the risks with unilateral imposition? What if you turn around to your staff today and say, we're going to put you all on furlough without getting their consent? Well, academic risk, but they could resign and claim constructive unfair dismissal. I don't expect many of them are going to do that in the current situation. The bigger risk perhaps for you is an unlawful deduction of wages claim, where an individual says, well, I didn't agree to go on furlough, I didn't agree to the reduction in my income, and therefore you've made an unlawful deduction of wages from me. The reason why that is a bigger risk is because an employee can bring a claim for unlawful deduction of wages within 3 months of the last deduction. So if you put someone on furlough now without their consent and you reduce their income and they're on furlough for, gosh, 2-3 months, hopefully not much more than that, you bring them back into the workplace when this is all over, they could then still bring a claim for the 20% difference for the period of time they've been furloughed, unless you've agreed a change to their terms and conditions with them. Now, a lot of clients are taking the view, yep, it's a risk, I get it, but you know what, I've got to weigh up the risks here, and it's the difference between the organisation having to cease altogether now or taking the risk of that claim at some point in the future. But just so that you're aware that that risk is there. So you do have the opportunity of imposition, but it comes with risks. The other option is that you try and get the employee's consent to the change. What I would say to you, some of you will have recognised trade unions, so you might want to work with them to get that consent. The unions were obviously party to the furlough scheme, so should be on board and hopefully should make that as smooth as possible. For those of you that don't have recognised trade unions, you might have employee consultative forums that you've set up. You might want to be starting to having conversations with them now about furlough so that you can get that in place as quickly as possible. And for those of you that don't have either, and if you're thinking about furlough, what you perhaps could think about doing as a step now, if you're thinking this might be something for a week's time or 2 weeks' time, is set up an employee consultative forum to try and make that consultation process as smooth as possible. So I realise I'm talking lots and lots and lots at you. I hope, I hope this is helpful. And the good thing is,
I'm
yes,
going to interrupt one, but I don't
yeah,
think that this has been covered. I'm trying to kind of juggle things here. But if you have a pool of employees and some are needed and some are not, do you
yes,
need to
coming
go
on
through a
to
selection
yes,
process? Sorry, I'll
yeah.
shut up.
No, 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 not at all, not at all. It's good because it means, thankfully, this information I'm giving you is the questions that you're asking. So that's really helpful, because I was just going to come on to say, how do you select who you furlough? You have to designate people or you have to designate people to be furloughed. Now, in some organisations, that will be very obvious. You know, if there's particular parts of your operation that are no longer required and you have a team of people that do that role, then you can designate them to be furloughed. Similarly, there may be people within your organisation who are absolutely critical, who are key workers who you cannot furlough. You can quickly identify who they are. What you might have, though, is this category in the middle. Say you've got 10 employees in a particular team who do a particular job, and you think, well, I don't need all 10. I could probably furlough, I don't know, 5 of them. How do you select who you furlough? And of course, there's that potential issue where you've then got staff, staff that you furlough who get 80%, up to the 2,500 per month, and then you have other staff and they're not doing anything. Then you have other staff who are coming in and working, and you may have reduced their hours, so they may be under 80%, and that might all seem a bit unfair. So how do you select who you're going to furlough? Again, answer is no clear guidelines at this stage. The advice that we're given currently is, as long as you can show you've applied your mind to it, you've been reasonable, and you've taken into account things like, well, what are the requirements of our organisation right now? What's the fairest way to try and achieve furlough? If we've got a union, or if we've got an employee consultative forum, have we spoken to them about how we're going to select and got them on board? Keeping a note on how you've decided to select who you furlough and who you don't, so that you can show you've applied your mind to it. And I think as long as you can show that you've taken a reasonable approach, and you've taken a decision based on the organisation's needs, and you've consulted to the extent you can in the current situation, I think you'll be absolutely fine. But another question that comes up in relation to this issue, say you've got a team of 10 and you need to furlough 5. We've been asked quite a few times now, well, could we furlough 5 people and then rotate it? So they do 2 weeks furlough, then the other 5 do 2 weeks furlough, and we rotate it like that. On the face of things, the answer to that, unfortunately, is no. You're not able to rotate furlough in that way, but it is something that's been raised with HMRC and with the government to say, look, we need to take a pragmatic approach to this. Is there any way that we could work on a rotating system? So I think it is something that's been considered by the government, but the view generally at the moment is, as the scheme's been published and the information that we've got so far, you can't rotate in that way. Okay. And the other thing that's been discussed is, well, could I, if I've got staff at home who have childcare responsibilities, for example, could I furlough them? And the answer to that is, if their role wouldn't otherwise be redundant, no, you shouldn't be furloughing them. But again, I know it's something that's been raised with the government to look at, well, can we broaden the furlough scheme so it's not just those that are at risk of redundancy, it's also those that aren't able to perform their role currently because of COVID-19 and because they're at home with childcare, etc. So there is some discussion on whether it will be extended, but just be aware that the scheme on the face of it doesn't apply to those individuals. Of course, if you're able to say that those individuals otherwise would be redundant, then you could furlough them. And of course, again, it comes back to the point I was making before. Who's going to look at all of that? Who's going to come to you and say, prove your case that that individual was otherwise at risk of redundancy? So that answers some of those questions. So that's selection, record and writing, identify your critical staff. That's process. What I'm going to do now, where are we at? Oh my goodness, sorry. Spoken far too much, Gillian. You can tell me to stop when you've had enough.
It's quite all right, because in all honesty, I will be picking up a lot of charity issues around governance, around insolvency, reserves, wrongful trading, things like that. I am planning on picking those up in a separate seminar with Stephen Phillips, so I can speak very briefly at the end of that, and people can hopefully join that next week. Off you go.
Okay. Well, I'll rush through some of the questions that we have had come in on furlough that I've not already covered, because I think these are all questions that everybody, to some extent, will probably want to know the answer to. I've spoken about how you implement furlough. what I would say to you is, and I hope you don't get into this situation, but if you decide that you want to try and get employees' consent to change their terms and conditions, if they don't consent and you decide to go ahead and implement it anyway, arguably you would then have to do collective consultation, which is your 30 days or 45 days consultation. I hope you don't get into that situation. I'm not going to go into it in detail for the purposes of this session, but if you want to speak to me about it separately, then please do. One question I've had is, will furlough be offered depending on the charity's reserves? There's no qualifying criteria. There's no indication that you have to demonstrate that you need the grant before you get it. And again, I think that's because of the emergency nature of furlough. People are not going to have time to check whether you have reserves that mean that you should or shouldn't be granted furlough.
Can I also just pick up on that very briefly, Morag, which is just to say that obviously the regulators, Oscar up here and the Charity Commission, are expecting that you will dip into your reserves to a certain extent, but not go wild with that. You know, I don't think there's an expectation that you absolutely utilise every last penny at the moment, but there is probably a more relaxed approach. So people will probably see their reserves going to a level that they feel less comfortable with. But no, Morag's right, there's nothing at the moment that's referring to levels of reserves.
Can you furlough individuals while keeping the organisation running? Yes, you can. You can select people for furlough. It doesn't only apply if you have to cease the operations of the organisation altogether. What else have I got here that we haven't already answered? Can we bring them back in? I've spoken about self-employed. I've spoken about, as I say, we're expecting an announcement on that today. There's chat that's going to be protection where it's 80% of your average earnings over the last 3 years, or 2,900, whichever is lower for self-employed individuals, and a similar kind of scheme to furlough. We've spoken about selection, furlough and holidays. Number of points here to make. Be careful. A lot of employers are starting to get concerned about, well, if we furlough staff, do staff continue to accrue holidays during that furlough period? It looks like yes, they do. What you don't want is to be in a position where you put staff on furlough for 2-3 months until this is all over. They come back to work and of course they've accrued and not taken their year's holiday entitlement, and then they say to you, right, thanks very much, but now I'm going to take my holidays. And suddenly you're left with no staff at a time when you absolutely need your staff to get yourself back up and running. What can you do about that? The challenge is you can't place people on furlough and then say to them, we want you to take 2 weeks of your holiday while you're on furlough. The options are pretty limited. What you could do is, prior to placing any staff on furlough, you could ask them to take their holiday entitlement and then you place them on furlough. Under the working time regulations, you have to give staff double the period of notice of the actual holiday, requiring them to take holidays. What do I mean by that? If you want staff to take a week's holiday, you have to give them 2 weeks notice, and then they have to take that holiday. So you might want to think about, do we ask staff to take holiday in that manner? The other question that's coming up a lot is, what if staff had already booked holidays? Of course, Easter coming up, and they're now saying to us that they want to cancel their holidays because their holiday plans have been cancelled or because we're in lockdown. The answer to that is you don't need to agree that they no longer have to take their holidays, and actually you might want to take the approach where you say to them, no, sorry, we need you to take your holidays just now, particularly if there's a downturn in work. And the other option that's been spoken about is, what you could do is allow your staff to carry forward more holidays into the next holiday year, so you're not in a situation where once this is over, hopefully at the end of this year, staff are rushing to take all of their holidays in the current holiday year. So just practical things like that to give some thought to. So that's furlough and holidays. Furlough and sickness absence we've spoken about. You're either sick or you're furlough. You can't be both. Pay we've spoken about as well. Other jobs we've spoken about too, so that's helpful. Yes, furlough and redundancy. I just wanted to flag to you, those of you that are familiar with having to go through a redundancy process will be aware of this. If you're making staff redundant, as part of your legal obligations, you've got to show that you've considered all options, all alternatives to redundancy before you actually make staff redundant. You know, you've got a legal obligation to mitigate redundancies as much as possible. One question we've been asked in is, does that mean if you, rather than furlough, if you go ahead with redundancy, does that mean that that will be an unfair dismissal because you are not looking at all other options as an alternative to redundancy before you go ahead and make staff redundant? Certainly, it will be harder for you to justify a redundancy if you cannot show that you've at least considered furlough as an alternative to redundancy. But I'm not saying that you can no longer make redundancies, particularly where they're related to COVID-19. But what you will have to be able to demonstrate is if you're in a position where you're looking at making redundancies, you'll need to be able to show that you've considered furlough as an alternative and you've got reasons why you've decided not to go down that route. And as long as you record those reasons and as long as they're reasonable, I think that will be okay. I want to move very quickly, if you don't mind, on to that's kind of furlough, as much information as I've got at the moment, and we will look at the other questions that are coming through and see if we've answered them or not, and if not, we'll try and pick those up for you. But just on other options, if what else is available other than furlough? Obviously, you can ask your staff to take an unpaid period of leave. You'll need to get their consent to that. It's a change to their terms and conditions. You can ask staff to take holidays. Again, I've spoken about, you've got that right to give them double the time in order to take the holidays, so 2 weeks notice for 1 week's holiday. Other options, you could agree with staff to reduce their hours and reduce their salary. Again, that'll be a change to terms and conditions, so you should get their consent to doing that. Employees have the right, any individual who has caring responsibilities for children under the age of 18 is entitled to take up to 18 weeks unpaid leave. So that's another option. Obviously, it's not as attractive as furlough for staff. Of course, it's not because it's unpaid, but just so you know that option is there. And I'm trying to think if there are any others. I think they're probably the main ones. Some of the things that clients have spoken to us about, particularly now that schools are closed, just to share with you in case it's something you want to think about, is being more flexible with your staff. If they can work from home, not necessarily working 9 to 5, but also you still need them to be available to provide a service if they need to be contactable. So one option I know a client has implemented is, as long as you do 4 of your core hours during 9 to 5, we don't care when you do the rest of your hours, you can do them whenever you want. So just thinking about things a bit differently from that point of view. They're also offering their staff the opportunity to do some of their hours at weekends. I don't know if that's a good or a bad thing. It's a funny thing, I think, when you're stuck at home all week and you think, well, what's the difference between the week and the weekend? I know for one, I'm trying to keep my weekends absolutely work free and make that difference between work and non-work. So there are some other options to think about. I also just wanted to flag to you critical staff. Many of you will be in a situation where you have staff that are not able to be in lockdown and that do have to travel into work. I appreciate that's a very difficult situation. What are your obligations there? Well, your obligations really are just to do all you can to protect those individuals. So is there any part of their job that they can do remotely, thinking about things a bit differently? Can we change the way that they do their role at all? If they are having to go out, what steps are you taking to implement social distancing as much as possible while they're carrying out their role? Obviously, there's the stuff around about hand wash, etc. Protective equipment, I know that's absolutely in the headlines, but to what extent can you provide protective equipment to the staff that are having to go out and work? But also thinking about, is there any additional training that you should be providing to your staff? Should you have new protocols in place about how they carry out their role in the situation that we're in? And the other question we've been asked actually by a number of employers who do have staff that still have to go out and work is, should we be providing them with a letter that they can then show to the police to show why they're outside if they're stopped and questioned? And that's something you maybe want to think about if you're in that situation. Finally, I promise, I just wanted to mention military reservists. Some of you may have reservists in your team or within your staff. The government have announced that they are going to call up military reservists. They have to give you, well, they're meant to give you 28 days notice of any call up as the employer, but they don't have a legal obligation to do that, so they may give you less notice. You do have a right to object to your staff being called up, but you have to show that you've got a very strong argument why you can't release them. And you can't, if you dismiss staff because they're reservists and because they've been called up, that has a criminal sanction. So just to flag that, we've got a note about all of that on our COVID hub. And there is discussions that the government might introduce a similar scheme for volunteers who want to be called up in relation to COVID-19, so being aware of that. A little bit of light relief for those of you that have got over 250 staff. Gender pay gap, the deadline for reporting has been delayed, so you don't need to worry about that anymore. And just on tribunals, all tribunals in person have been cancelled. The idea is that a lot of them will move to hearings by technology, but all tribunals, I think it's all hearings up until the 19th of April have been postponed currently, and that's to give the tribunal some breathing space to set up their systems and their structures. Ooh, Gillian.
Can I drag you back for one more question
You
before
can,
we
yes.
leave you? I suspect the answer is no, but is there a furlough staff communication template yet?
Yes, yes, we have pulled together, in terms of your documentation to be thinking about, we have pulled together a letter to kind of issue to staff to say we're thinking about furlough. I'm not sure the best way to make that available to you. We can have a chat about that, Gillian and I, perhaps at the end of this, and see if we can circulate that. The other thing to be thinking about is your correspondence. If you are putting staff on furlough, what your correspondence says. I can't really give you a template letter for that because much will depend on your contract of employment. Obviously, we can help with that to the extent we can. And there's another document I was thinking about, it escapes me. It'll come back to me. But we can certainly share the kind of, here's a letter to issue to staff to say you're thinking about furlough. If that would be helpful, that's no problem at all.
Okie dokie then. So we've got 1 minute to go, but I will
Sorry.
go on for a little bit. Feel free to stay on if you want to. Monique, I don't know if you need to put your video off just now because they might still be seeing your lovely smiley face. The message from me really is one of the main things we have been hearing from organisations at the moment is concerns about how they hold meetings and how decision making takes place. And my goodness, was there ever a time when third sector organisations were being called upon to make such critical decisions and at such pace? It's all happening so fast. Normally, I am an absolute stickler for what is in the Constitution, and the Constitution is king. Good governance, stick to what is in there. I'm not saying rip it all up now, but flexibility is key at the moment. And anyone who has seen any communications from Oscar or the Charity Commission, they are very aware of the position that charities in particular, and I'm talking about charities in the main. Obviously, we'll also have KICs as well. People from KICs who are on here, I would hope a similar situation would apply to them. In terms of convening meetings, you've got your difference between meetings of members and meetings of directors or the board of trustees. Very quickly, and I'm sure I'm teaching my granny to suck eggs here, but if I had £1 for every time I'd heard, we don't have members, we've only got directors. If you're a charitable company or if you are a SKIO or an unincorporated association, you will have both levels of decision making. In reality, they might be one and the same people. So your members and your board might be exactly the same individuals, but they are responsible for taking different decisions, and things have to be minuted in that way. The focus on the moment is very much on the board, and I'm a board member myself, and I'm similarly well aware of the pressures. The board is responsible for running the organisation, the financial aspects. The members really only pitch up to the AGM. They have the right to receive a copy of accounts. They elect board members where there is a democratic election structure. But really, their responsibility for decision making is limited to big constitutional decisions only, changes to the name, changes to the objects, other changes to the constitution, and heaven forbid, a winding up resolution. So I'm going to look at both meetings of members and meetings of the board. Meetings of members, if you can park them just now, if you can postpone them, if you don't need to have them, let's just do that, because there is a bit more formality involved with those. Notice of meetings. For board meetings, in all likelihood, your constitution will say reasonable notice has to be given to the board. Well, what was reasonable a couple of months ago is very different now. So 7 days would probably have been the norm a couple of months ago for convening a board meeting. 7 hours may well be the position now, given the sort of decisions that are being taken and the pace at which they have to be taken. Notice of members' meetings, I'm afraid, will still need to follow what is in your constitution and what is in statute, normally 14 clear days notice. And I can't imagine there's anything that desperately needs done by the members where you would have to convene it at short notice. But for charitable companies, there is a consent to short notice process, but it does need a very high level of approval by the members to do that. So again, unless there was something like a winding up resolution, you probably don't need to be doing anything with the members at the moment, unless your AGM is due, or if you're looking to extend your objects urgently to respond to the changing landscape as a result of the coronavirus. In terms of what goes in the notice, for a board meeting, normally those of you who are in senior management teams, you will be preparing reports and all sorts of beautiful documents to go to your board. That, I mean, that can't really happen to the same extent at the moment. And again, don't worry about that. Even an email with the headline points to the board, just sufficient notice, sufficient detail so they know what issues they're going to be covering. Whereas for members, if it were a special meeting of the members, the exact wording of the resolution, if it is a change to the constitution, there's really shouldn't be anything prohibiting you from doing that. So you do need to stick to what the Companies Act or the SKIO legislation would expect in that regard. Quorum, you do still need to be quorate for any of your meetings, but there are slight kind of caveats to that, which I will come on to later. The big one at the moment is video meetings. Zoom is now part of my daily vocabulary, having never actually heard of it a couple of months ago. Board meetings by video are absolutely fine at the moment. If the board members can see one another, if they can hear one another, if they can participate, that is absolutely fine. Don't worry unduly that your constitution doesn't specifically allow for that. People will be regarded as present for the purposes of the board meeting, participating in that way. Telephone conference, probably a lot more constitutions allow for that, and that is fine too for board meetings. If you have to have an AGM, it is, like I say, it would be preferable if you could postpone it. And again, the messages from Oscar are that they are going to be relaxed on this. There is provision in the Companies Act for those who are companies, which would actually allow you to do it electronically, provided there's nothing specifically precluding this in your constitution. And it's really unlikely that there is. So as long as people are able to attend, speak, and vote in some way, you could theoretically do a members' meeting electronically. I would think the likelihood of anyone challenging this would be low, and that the regulators would hopefully be pretty lenient on some of this sort of thing. Quorum. For a meeting of the members, quite often your constitution might say that there has to be a certain number of people physically present. Now, although there have been cases whereby you've had some people present forming a quorum at a central hub and others participating by video conferencing facilities, and that's been fine. At the moment, we're not going to have a central hub for any general meeting. Everyone would be participating remotely. And again, whether or not the quorum could be deemed to have been constituted, I would hope that any regulators would actually take account of the current circumstances and would be lenient in that regard. So the main message is, in terms of your meetings, if you can do them by Zoom, especially for board meetings, absolutely fantastic. Minute them, make sure all decisions, especially where decisions are being done kind of out of the context of formal board meetings, make sure you can show the way in which decisions have been reached. But like I say, I think there is just an appreciation across the board that these are strange times we are living in, and that there would be leniency. What I'm also being asked about a lot at the moment is, do we need to run things by the full board? Can we use some kind of executive board, some kind of subcommittee who can be called upon quickly to make decisions? I've got mixed feelings on this one. I think it is really sensible to have a subcommittee like this who can certainly be a resource to be called upon by the senior management team to give advice and guidance. But actually, a lot of the decisions that are being taken right now are absolutely business critical. For those of you on the boards of charitable companies, this is probably quite a scary time in terms of the wrongful trading regime. Wrongful trading is something that does not apply to SKIOs. The test for this is that you should not continue to trade as a board when you know, or ought to have known, that there was no reasonable prospect of avoiding insolvent liquidation. Even at the best of times, timing is everything in the wrongful trading test. And at the moment, it really is a challenge to know where the tipping point is. Morag's been talking about, the job retention scheme, there are these loans that are available, government concessions on payment of taxes. We've got the Third Sector Resilience Fund and other funds available, but it takes time to access all of this. And as Morag was saying, some of the guidelines aren't even available yet. So this is a strange time where rather than throwing in the towel too early so as to protect creditors, there might be merit in actually continuing to go and seeing if you can take advantage of some of these initiatives, but it's really difficult to know. And if this is being dealt with by a small subcommittee rather than going to the full board, how can the full board be said to be fulfilling their duties as charity trustees? So what I would recommend is look at your existing schemes of delegation, look at whether any of that needs beefed up for a particular existing subcommittee or for a new subcommittee. Send an email round to all of the directors and get all of them to unanimously approve the remits at high level for the committee. You could maybe set thresholds of materiality in terms of things that you are happy for that committee to advise on, maybe in terms of press releases, but where things have major financial implications, that might be something you want referred to the full board. But ultimately, in terms of the major decisions, although I think actually it's brilliant to have a group who are meeting regularly on Zoom and who are debating and discussing issues. Some people have said, can we just do our business by email? Well, we don't build that into constitutions because it is really not best practice in terms of good governance. People are sometimes reluctant to commit to writing what they would say verbally in an actual board meeting. And you can't really tease out the issues properly without full and frank discussions. So to have at least a core group of board members working with staff discussing these issues and then making recommendations to the board at large on the most key issues and having almost like email ratification of that with unanimous approval from the board, which would constitute a resolution in writing by the board, I think is really the sort of best we can get to on that. So that is just a few minutes on some of that stuff. I know it is less exciting and less business critical in some respects from what Morag was talking about, but I'm going to try and pull together more of this. We're also being asked a lot about electronic signatures. Please look at the Coronavirus Hub on our website. There is information on that there. Someone had asked a question actually about accounts and finalising accounts. Just to say, first of all, there is quite often a misconception, especially for companies, that accounts have to be presented at an AGM and approved by the members. No, they don't. All that has to happen is that accounts are circulated to the members, and they have to be circulated before the earlier of when the accounts are submitted to Companies House or when they were due for submission. So it doesn't matter that they are not being accepted by the members. The board can approve those, but via a Zoom meeting, they can be signed off electronically and then circulated to the members. But there is information on electronic signatures available via our Coronavirus Hub page. Again, we will look at all, I'm seeing this whole list of questions down the side here. Morag and I will look at all of that and pull some of that together. It might be a recording of one of us kind of covering off some of that. Someone else had also asked a question about reserves again that I just wanted to come back on. Just to reiterate, for the job retention scheme, reserves are not relevant, but in terms of some of the other schemes, I've not looked at the detail of what's available via Social Investment Scotland, via the Third Sector Resilience Fund, and even the business support loans. This is being resourced through private lenders, and there will be elements where they are looking at reserves. Someone had asked whether it's relevant that you are being funded by a local authority. I wouldn't imagine that the terms and conditions for these initiatives would go into that level of detail, but it is also always possible, and we would need to check that. But they will, probably some of these will look at levels of reserves, but not for the job retention scheme. Morag, is there anything else you're still wanting to cover if you're still around?
Yeah, no, I'm still around, but no, nothing else to cover. I've been answering some of the questions where I can, just on the side. I do need to say some of them are quite specific. We need to be careful that we're only giving general advice on this and not individual advice, but happy to help if we can.
Okay, well, thank you so much, everyone, for taking time out of your day. Hopefully, it's broken up some of the homeschooling or whatever else you're doing. My children are currently barricaded in a room with my husband watching Aladdin, so I'm going to go and retrieve them and very much do flexible working, as Morag said, because we are fortunate enough to be able to do this. But Morag and I will take a look at everything. I will also have someone be in touch about further charities sector. So thank you very much, and I hope everyone is managing. Oh yeah, someone's saying time to let the kids out. Is that my kids or yours, Jerry? I hope everyone is managing to get through this with some kind of smile on their face. I know it's a really, really difficult time. Thanks very much, everyone. Thank you.
Thanks. Take care. Bye now.